Welcome to Human Rights in Australia, Lesson 2. You should have access to the booklet as linked in the email I sent you last week. If you haven't, please email me and ask for one. So let's go. In this lesson, we talk about the history of human rights and also the history of Australian human rights. So there are two ideas about the history of human rights. Some people argue that the concept of human rights is a modern one and was born with the Universal Declaration of Human Rights, or in some cases as late as the 1970s. This argument suggests that the idea that we have rights because we're born human, that idea did not exist before modern times, and that before modern times it was the state or rulers who gave people human rights. If you want to know more about this argument, you can read Moyen, The Last Utopia, Human Rights in History, that develops that argument. On the other hand, people or institutions such as the Human Rights Commission in Australia argue that human rights has a continuous history that goes back to cultures as old as Indigenous cultures, and that these cultures and other early cultures had an idea that just because you're a human, you deserve justice, and there was an idea of ethics that goes way back before modern times. And that's the history that we're going to look at today. So the idea that human rights has a continuous history starts with the idea that people are born human and therefore they have rights, and that this was recognised as far back as pre-written culture. So Indigenous people have an idea of ethics and justice that is owed to people because they are people. This idea has also been traced back to Buddhist, Hindu, Christian, Islamic and Jewish societies, also have an idea about ethics and justice. During the Enlightenment and Renaissance, this idea developed, and people started to have an idea of a natural law which was above the law of rulers. So the idea that rulers could be questioned because the laws they made were not just. And then the US and the French revolutions put these ideas into documents such as the Declaration of Independence and the Rights of Man and the Citizen, which was the French Revolution equivalent of the Declaration of Independence. During the 19th and 20th centuries, there were advances in rights such as the abolition of slavery, expansion of education and campaigns for cultural equality. We can see that during the early years of the 20th century, people such as Mahatma Gandhi started campaigning for rights for Indian citizens, and the American Civil War going back before that was fought on the basis of the abolition of slavery, that slavery was morally wrong. So there was an idea of rights there as well. So when World War II came along, there were many breaches of human rights, such as the persecution and murder of people on racial, gender, identity, disability and cultural grounds, which involved concentration camps, slave labour and euthanasia of those with illnesses or disabilities. It also included the confiscation of property, goods and destruction of civil and political rights. So after World War II, the victors of World War II decided that they wanted to codify the idea of human rights into a document. So the Universal Declaration of Human Rights was published in 1948, and it was a direct response to the breaches of human rights during World War II. And since that time, the United Nations has published different declarations and covenants as a response mainly to social movements. So you can say that the International Convention for the Elimination of Racial Discrimination, which was published in 1965 and adopted in 1969, was a response to the civil rights movement. And then similarly, The Rights of Women, that was published in 1979, was a response to the feminist movement of the 1970s. So the United Nations is constantly updating their idea of rights, and a lot of their updates are responses to events in the wider world. So there's an interaction between social movements and cultural movements and official declarations and covenants by the United Nations. So what about Australia? Well, a lot of the framework for Australian human rights comes from England, but we have, of course, developed our own independent human rights framework. And we have signed many international human rights agreements. And there are rights that we have in Australia in our constitution, through Parliament and through the courts. So Australian human rights, the human rights you have as an Australian, come from three places. The Constitution of Australia, which was formed in 1901, our Parliament, so the laws passed by our politicians, and the common law, which is the law through the courts. So the Australian Constitution was formed by a committee, and the picture here is of the gentlemen who were on that committee, and you can see most of them, well, they were all white men, and they were all property owners. So when Australia became a country, and the states got together to form Australia, these men wrote our constitution. And most of our constitution is about the powers of politicians and the way the Parliament is set up. So we have a Senate and a House of Representatives, and the constitution talks about how these work. As far as human rights go, there are only 5 rights in our constitution. The right to trial by jury, the right to vote, freedom of religion, freedom from discrimination because of state of residence, and property rights. There is no right to freedom of speech in the Australian Constitution, although in 1992 the High Court, which interprets our Constitution, said there is an implied right to political speech because we are a democracy. What they mean by that is Australia is set up as a democratic country, therefore we have a right to talk about politics. But that's very limited, and I think the ruling was mainly about giving out how to vote material before elections and advertising on television. So we really don't have an expanded right of free speech at all in the Constitution. So why didn't these lovely gentlemen with their beards incorporate a Bill of Rights into our Constitution? Okay, so the Americans had a Bill of Rights, the French had a Bill of Rights. Why didn't we have one? Well, the primary reason was because of the White Australia policy. The White Australia policy was one of the first laws passed by Australia as a country, and basically it stopped people who were not white from coming to Australia. It discriminated against people immigrating to Australia on the basis of the colour of their skin. Now, this was a policy, openly racist policy, and eventually it caused a lot of problems for Australia, particularly during the civil rights movement. Now, I mentioned the International Convention for the Elimination of Racial Discrimination. That particular convention was published by the United Nations in 1969. But Australia couldn't sign it because we had a racist immigration policy. And towards this, in the 1970s, Australia was at real risk of becoming isolated from the rest of the world like South Africa was during the apartheid era. So we were in danger of being subjected to trade sanctions and boycotts and sporting boycotts because we had a racist immigration policy. So it wasn't until the 1970s, when Gough Whitlam became Prime Minister of Australia, that Australia abolished the White Australia policy officially. And that because it wasn't abolished till the 1970s, we could not sign the International Convention for the Elimination of Racial Discrimination until 1975, which is a disgrace when you think about it. But the main reason we don't have a Bill of Rights in Australia is because of the White Australia policy. So going back to the other places where we get rights from in Australia. So the first one is through the Constitution. The second one is through common law. Common law is law made through the court. So it's court cases, precedent, what they call precedent in law. A lot of our law was inherited from the United Kingdom, and Australian courts change the law when they make a ruling on a case. And we can get rights through common law. And the major place that we get most of our human rights from is from Parliament, so from our politicians. Common law can be changed by Parliament, by our politicians passing a law in Parliament. So basically a lot of our rights come from politicians in Canberra sitting down and passing a law. So through these laws we have the Disability Discrimination Act and the Racial Discrimination Act of 1974. And we also have marriage equality. So if you look at marriage equality, this is an example of how Parliament can restrict and extend human rights in Australia. So before John Howard, marriage in Australian law was defined as a partnership between two people, but it didn't specify the gender of the two people. But Parliament, the Liberal Party, changed that, changed the marriage law so that marriage was defined as a partnership between a man and a woman. And that's why we had to go, Parliament decided to send a referendum, wasn't a referendum, but a poll to the people about marriage equality a few years ago. And because everybody, the majority of people in Australia voted in favour of marriage equality, the Parliament changed the Marriage Act again to say that marriage was a union between two people and didn't define gender. So that's just an example how rights can be taken away and given back just through Parliament passing laws. If we had a Bill of Rights, they wouldn't be able to do that. So today we've just spoken about the history of human rights as a concept, and we've also spoken about where rights in Australia come from. And for homework, and just to reinforce what we're speaking about, watch the video on page 18 in the booklet and answer the questions. That's about the history of human rights. Read the article on page 28, which is about Australian rights, and see if you can answer the questions on page 29. I hope you've learned something today. Enjoy your week. See you next week.